Title 13, Crimes Against Honor. There are different kinds of defamation. We have defamation in writing, we have libel. We have also oral defamation or slander. And then we have also the so-called defamation through action, slander by deed. Libel is the public and malicious imputation of a crime, vice, or defect, whether real or imaginary, or of any act, omission, condition, status, or circumstance, tending to cause the dishonor or discredit of a natural or juridical person, or to blacken the memory of one who is dead. That is how libel is defined under Article 353. Based on the definition of libel under Article 353, there are 4 elements of libel. First, that the offender makes an imputation or allegation of a crime, vice, or defect against the offended party, whether real or imaginary. Second, there is a publication of the said allegation. Third, the identity of the person defamed. And lastly, there is malice on the part of the said offender. The second element requires that there be publication. Publication, the element of publication is satisfied not by publishing the said libelous article in the newspaper. It is not required that it be published in any newspaper, in any books. What is only required is that the said libelous article, libelous statement, be read or heard by any third person. The element of publicity is already satisfied. Insofar as the element of identity of the offended party is concerned, the law does not require for this element to be present that the said libelous article, the said libelous statement must expressly state the name of the person defamed. The law does not require that the person defamed be described in detail. It suffices that anyone reading the libelous article, anyone hearing the libelous statement could pinpoint to him as the subject of the said defamatory article or defamatory remarks. That is satisfied, that is sufficient enough to prove the identity of the person defamed. The last element is the existence of malice. For every defamatory statement, the law presumes malice. That is, if the author could not state a good reason, a justifiable motive for making the said statement, for writing the said libelous article. So for every defamatory statement, the law presumes the presence of malice. This is malice in law. Whether it is true or not, it doesn't matter, for as long as the author thereof could not state a good reason, a justifiable motive. The law presumes the presence of malice in every malicious statement or allegation, except in case of privileged communication. There are 2 kinds of privileged communication. One is absolute privileged communication, and the other one is qualified or conditional privileged communication. In case of absolute privileged communication, as a rule, it is not actionable. You cannot file a case of libel if it is an absolute privileged communication. However, in case of qualified privileged communication, you can file a case of libel, but the burden to prove the presence of malice lies on the complainant. He has to prove that when the author published the said libelous article, that when the author stated the said libelous statement, there is on his part malice. This is known as malice in fact. Malice in fact must be proven by the complainant, that is, the alleged person defamed. If he failed to prove malice on the part of the said author, then it will be an acquittal, because this time the law does not presume the presence of malice. Is proof of truth admissible in the crime of libel? As a rule, proof of truth is not admissible in the crime of libel. It refers to any allegation, whether real or imaginary. So whether it is true or not, it is not material. it is not admissible. The fact is, your intention is to malign this person. However, in the following instances, proof of truth becomes material. First, when the allegation or imputation pertains to a crime. Whether the said person defamed is a public officer or a private individual, proof of truth is admissible in evidence. Second, when allegation or imputation pertains to the work of a public officer or employee, proof of truth is now admissible in evidence. So in these instances, proof of truth becomes material. Where do you file a case of libel? Under Article 360, you can only file a case of libel before the regional trial court. So it is only the RTC who has original jurisdiction over libel cases. But isn't it that the penalty for libel is only prisión correccional in its minimum and medium period under Article 355? Therefore, since it is only prisión correccional, it is within the jurisdiction of the MTC. But the RPC is a substantive law. Therefore, it is over and above the rules of court, a procedural law. Hence, Article 360 prevails over the rules of court. Libel cases are only within the jurisdiction of the RTC. It cannot be filed before the MTC. The accused stated defamatory remarks against the complainant, or X stated defamatory remarks against Y in an interview over the radio. What crime is committed? Libel. X stated defamatory remarks against Y on national television while being interviewed. What crime is committed? Libel. X stated defamatory remarks or wrote, placed in the internet defamatory remarks against Y, imputing against Y the commission of a crime. What crime is committed? Libel, in particular cyber libel. X, in a general meeting attended by the entire people in the barangay, he stated defamatory remarks against Y with the use of an amplifier for everybody to hear. What crime is committed? Oral defamation or slander. Libel can be committed by means of writing, printing, lithography, engraving, radio, phonograph, painting, theatrical exhibition, cinematographic exhibitions, or any other similar means. That is provided for under Article 355. Radio is included therein. Television, according to the Supreme Court, is within the meaning of other similar means because of its coverage. How about the internet? The Supreme Court has upheld, in the case of Dicini, the Supreme Court has upheld cyber libel. The Supreme Court said, cyber libel is nothing new. It has long been in existence since the RPC because it is within the meaning of other similar means. Hence, it is constitutional. In the other problem wherein I said that in a public gathering, the X stated defamatory remarks against Y using an amplifier, the crime committed is no longer libel, it is oral defamation because of the coverage. When you say oral defamation or slander, we have two kinds. We have either grave oral defamation or slander, and we have simple oral defamation or slander. It is grave when the said defamatory remarks are serious and insulting in nature. Take into consideration the grammatical sense of the statement, the facts and circumstances under which the statements were made, and the relationship between the offender and the offended party. The same is true in case of slander by deed. Slander by deed does not refer to words or statements. This refers to acts intending to defame another person. If the said acts, defaming, maligning another person, is serious and insulting in nature, it is grave slander by deed. Otherwise, it is only simple slander by deed. X is the counsel in a case, and X sent a letter to the opposing counsel. The said letter was inside an envelope, but the said envelope was not sealed, and it was placed inside the mailbox in the house of the opposing counsel, that is Attorney Y. And the wife retrieved the said letter from the mailbox. The wife, since it is the envelope has no face, it was not sealed, the wife opened the letter. Not only the wife, the children also read the letter. And in the said letter, it is stated that Attorney Y is stupid, has poor grammar, poor in English, ignorant, and then it was stated therein that yours in Satan's way. And because of this, the wife was mad. What kind of lawyer is this? His husband is being called all these names. And the wife told the husband no longer to handle the case. They said Attorney Y thereafter filed a case against Attorney X because of this letter. The argument of Attorney X, according to him, he is not liable, it is a privileged communication and there is no publicity. According to him, there is no publicity because it was not read by any third person. Is the argument correct? In the case of People versus Buwatis, the Supreme Court said the argument is wrong. Supreme Court said the wife and the children who read the said malicious letter are within the meaning of third persons insofar as publication is concerned. Since the wife and the children read the same, it has already been published. The columnist, he is a writer in this tabloid, Bandera, and he has this column. The column, let's say, hit kahit sino. And he stated therein, this time he was hitting this BIR officer in Manila, who happens to be a lawyer. And he said, Attorney W, this lawyer, a BIR officer in Manila, is a buwaya. Kagaya ng buwaya sa lakos niyang t-shirt, lumalaki na lumalaki. Yung tiyan niya lumalaki, bundat na bundat. Yun yung sinabi niya sa kanyang article. And everyone knows that he was referring to this attorney in BIR Manila. And everyone who can read it in the said tabloid knew he was referring to this attorney. And so the attorney filed a case of libel against the columnist, against the publisher, and against the editor. Are they liable of libel? They are liable of libel. Under Article 360, the author, the publisher, and the editor can be criminally liable for libel. Their defense is that this is a privileged communication, and it pertains to the work of a public officer being a BIR officer. Supreme Court said yes, it pertains to the performance of function of a public officer. But he is accusing this person of the commission of a crime. And the said accusation has no basis at all because in the said malicious publication, there were no details why he was said to be a buwaya and a criminal. So in that case, the said offender was criminally liable for libel. There is this recent case. There was this case filed before the fiscal's office, and the fiscal resolved the case of estafa. The fiscal resolved the case in favor of the defendant and respondent, and so the fiscal dismissed the case. The counsel of the complainant was so mad. The counsel of the complainant filed a motion for reconsideration. It was denied, and so it was brought up to the DOJ. And in the said petition for review, the said counsel for the complainant was saying that this moronic resolution of the investigating prosecutor, who is very stupid, you can see from the flip of the skirt, from the flip of her skirt, her stupidity, this has no basis in law. And calling other names, the said fiscal, the said investigating prosecutor. And so the investigating prosecutor filed a case of libel against the said attorney. Is the said attorney liable for libel? The argument of the attorney is that it is an absolute privilege communication because it is a pleading filed in court. Therefore, totally, it is not actionable. Because when you say absolute privilege communication, totally it is not actionable. Pleadings filed in court, privileged speeches made by members of Congress in the House of Representatives, in the Senate session hall, malicious statements stated in open court by witnesses, these are all absolute privilege communication. You cannot file a case. And so, the argument of the attorney, this is a pleading. Therefore, it is considered as an absolute privilege communication. Supreme Court said, although in cases of absolute privilege communication, the rule is that it is not actionable, it must pertain only to the issues in the said case. Here, the said attorney did not concentrate on the issues in the case. He already attacked the said fiscal, the said investigating prosecutor personally. And all these attacks were done with malice. Therefore, it can no longer be considered as an absolute privilege communication. And here, the Supreme Court held the said attorney liable for the crime of libel. X was attending a party. X passed by this group of women in one table, and she overheard them talking about her. And they were saying that she is a concubine. That she is a concubine of the Solicitor General. Hindi siya na Solicitor General. So, that is not true. She is not the concubine of the Solicitor. Baka masubo ako dito ng taga-Solgen. Ano naman yun news everywhere. And so, when she heard that she is being there, these women were talking about that she is the concubine of the Solicitor General, she was so mad. That is not true. She is not the concubine of anybody, more so the Solicitor General. She wanted to file a case against this woman for spreading rumors against him, malicious rumors against him. What case may she file against this woman? She can file a case of intriguing against honor under Article 364. Intriguing against honor because their acts has the intention to malign, to blemish the good reputation of this woman. She does not know the source of the said rumor. But what if she conducted an investigation and she learned the source of the said rumor and it was W? What case may she file against W? Oral defamation. Grave oral defamation. Because it was serious and insulting in nature. It is attacking her morality as a woman.